Back. The next 24 hours could make or break President-elect Uhuru Kenyatta's second term, with the deadline within which his victory in the just concluded repeat presidential election can be challenged in the Supreme Court, lapsing at midnight tomorrow. Now, this amid concerns that several NGOs reportedly preparing a petition are in the crosshairs of the NGOs Coordination Board for allegedly contravening NGO regulations on registration, audit and financial probity. So what are the likely grounds if a petition is filed, and what happens at the stroke of midnight tomorrow if no petition is filed? To put these matters into perspective, we talk to lawyers now, Kamodo Waiganjo, Steve Ogola, and Edwin Sifuna. Thank you all for making time for us tonight. Talk to us, the text us on 22422, and on Twitter use the hashtag Sunday Live. Gentlemen, the deadline is tomorrow night. NASA says it will not go to court. Some Jubilee leaders say NASA is going to use civil society organizations to go to court. You are here, you're from NASA, Edwin Sifuna. First, what is happening exactly? Is that what's going to happen? What has been alleged?
Hussein, from our perspective, we are very clear that there was no election on the 26th. So there's nothing to challenge in court. We have demonstrated more than once that we are very able to file and prosecute matters on our own, and our own name. We have very good lawyers that have done it time and again. So when we tell you that we are not interested in validating what happened on the 26th to pass off as an election by attempting or purporting to challenge a non-starter, you cannot go to challenge something that did not happen. Our position is very clear. There was no election on the 26th, so you will not see a petition by NASA.
And NASA is not sending anybody else to court, because that has already been said now by some
Jubilee
leaders.
it is a bit presumptive of you to imagine that only people who are sent by NASA can go to court.
I'm saying this is an allegation that has been made.
That is an allegation that I would not want to respond to, because we are a nation of over 40 million individuals, people who have capacity to think for themselves and to say, this is something that I want to challenge in court. I mean, so if somebody appears in court tomorrow with a petition, you are not going to say they have been sent by NASA. There are people in this country who are non-political, who also want to see justice and electoral justice for that matter. For us, we have taken a position that because there was no election, there's nothing to challenge. Okay. I'm sure there are people who believe there was an election and that it was not done properly, and they will challenge the same.
But NASA said, through their leader and the leadership of NASA said very clearly, this was a sham. You said there's no election, it was a sham. I'll ask this to Kamodo Waiganjo. Did you expect them, now that they're saying this is a sham and a fresh election should be held again after 90 days, did you expect them to challenge this in court?
I doubt that NASA would directly go to court to challenge an election which, one, they did not participate, and as Sifuna says, was not there. I think the only thing is that privilege of determining whether an election happened, whether it was a sham, is actually not NASA's in-law privilege. Determining. Making the allegation, yes, but the determination whether there was an election, whether the election met constitutional standards, that has been allocated by the Constitution to another institution. So ultimately, it's that institution that will tell us whether there was an election or it was a sham. And that institution has shown that it has the capacity to actually cancel an election. So I am not sure that NASA stands on very strong constitutional grounds to say because there was no election, so therefore, because that is not their province. But of course, you know, I mean, freedom of expression, freedom of whichever, all the freedoms that are given in the Constitution are available to NASA. But the reality is that it is important, as we continue to strengthen our institutions, that we ensure that we take this through the constitutional processes that are anticipated by the Constitution. Let the ultimate determinant of an election be the courts. And I think Jubilee is bound, if the courts determine one way or the other, to respect that decision. I think that is the only way we're going to grow a constitutional democracy.
Steve?
Well, I think I was saying it's not open to us to say that there was no election. Well, you may say that the election was fraudulent, was shambolic, was a sham, but you know, the election of October 26th was a consequence of the law and a consequence of Supreme Court order, which said let there be an election in 60 days. There was not a subsequent order vacating that election, so the legality of that election is not in doubt. However, if you want to challenge that election, if somebody files a petition, then that will be tested in court. Remember, I was saying, it's not a must that people must challenge the outcome of an election. If the outcome of an election is not challenged, then there's the presumption that the election was conducted in a manner that was satisfactory to all parties and met the threshold under the Constitution. What I can't do as a lawyer is to have doublespeak, because as Kamodo says, if you claim that the election was fraught with challenges, and especially fraud and falsification, and the election result was already predetermined in advance, then there is a formal, the Constitution offers us a predictable pathway. You know, after the declaration of results, That marks the end of the electoral contest at the ballot. It opens another end of electoral contest in court. That is the electoral dispute resolution. If somebody wants to go there, and it's open to any Kenyan, not necessarily NASA, any Kenyan can go there. If nobody goes to court by end of tomorrow, the presumption in law is that Kenyans have found that election to be satisfactory. In any case of saying, if somebody goes to court, let us not neglect that the Supreme Court has two options. One to nullify and the other one to validate that election. Therefore, I see a possibility that maybe sometimes, if you may have some instances of fraud and falsification, but you don't think they may rise that level of nullification, so it's safer not to go, because if you go to court and the court actually says that this election, despite the challenges around it, management, we find that it was largely satisfactory, they know that takes away some legitimacy in terms of the claims that the election was shambolic. Okay. So I think we must understand it in that context also.
Hussein, one of the things that I'm asking myself, you see, for us, we are very clear that there was no election. We're not saying it was fraught with irregularities. We are saying there was no election. Number two, one of the biggest and primary concerns for us is, do we really still have a Supreme Court? Because of what happened on the 25th.
I'll come back to that. I'll come to that. So I'll come to that. But on this matter of saying there's no election, so let's say NASA doesn't go to court, because you say NASA isn't going to court.
Yes.
So any other Kenyan, whether some are alleging NASA will sponsor, let's even not say NASA will sponsor, any other Kenyan who goes to court.
Yes.
And the case is either upheld, and the election is either upheld or is nullified. If the election is nullified, and somebody went to court and it's nullified, will you participate in the fresh election?
We have made very clear the conditions under which we will participate in anything called an election. We are saying we need a free, fair and credible election. If such event will ever be organized in this country, a free, fair and credible election, you can count on the fact that NASA will participate in those elections.
That will be ordered by a Supreme Court.
I am saying, if we
get there, isn't it? But here you are saying, here you are saying
yes,
that you're not going to court because you don't recognize what happened.
Exactly. I am saying you cannot go to court to challenge something you believe did not happen. But I am saying, if we as a country will get our act together someday, at any point in the future as a result of whatever process, that we have free and fair and credible elections that people are free to participate in, and the result is not predetermined, such as a sham on the 26th, then we are free to participate. I don't think anyone can stop you from participating.
Okay. Hussein, let me say something concerning the political formation, both Jubilee and NASA. I think in this country, it is only the political class that think that they are not immune to legal processes and that they can vacate provisions of the Constitution at will based on what they think is convenient to their own partisan posturing or positions. The Constitution, which Sifuna knows very well, he has a very detailed understanding of that Constitution. He knows the Constitution provides that if nobody challenges this election, then Uhuru will be sworn in as a matter of course within the next remaining 7 days. And if he's sworn in within the provisions of Article 142, a president is sworn in for a term of 5 years. So I'd like to learn, so that we can also appreciate the new knowledge from NASA, how we can innovate and get another election within those, because remember, Uhuru Kenyatta must then voluntarily resign, and he must resign with Ruto. This is a textual analysis of the Constitution, how we want to vacate these positions in law, where someone is sworn for a term of 5 years. I'm not commenting on the veracity, I'm not commenting on the legitimacy or legality of the election, because it's not open to us to pontificate on social media or maybe on platforms like this. The proper forum to pontificate on this issue about election management, whether it was indeed fraught with fraud and falsification, is the court. If nobody is there, then the issue that Uhuru Kenyatta is sworn in, passed the Constitution for 5 years, I'd like us now to do some new learning, because there seems to be a new learning, how we can then now go back to an election.
If you want to learn,
in 5 years, yes.
Hussein, you know, here's the reality. NASA decided not to participate in an election on the basis which has very little constitutional foundation. So they're actually now operating outside of the confines, the structures and the processes set out in the Constitution. What they are finding difficult is how to come back so that they can then operate within the four corners of the Constitution. Because remember that when the elections were nullified last time, they were nullified on identifiable grounds. There were 4 grounds. On the basis the election was announced before all the FOBs were all the returns had come on Form 34A, that there was no electronic transmission of the results, that there were dubious forms, and that there was refusal to access read-only the server issue. Those were the 4 grounds. So if IBC was able to show that they can resolve those issues, and they did in their response to the reducible minimums, it actually became very difficult for NASA to make a constitutional case, not a political case. A political case they can make, a constitutional case for the boycott. Now, what they're finding difficult is to make a constitutional case for delegitimizing the election that happened to. Politically, of course, they can, because ultimately there are only 2 institutions that are involved in this process. The IBC, which has a constitutional right to run an election, and the court, which determines whether what IBC did is within the constitution. No participant can be the one who makes the determination.
But are there grounds to challenge this election?
Of course there are grounds. There are always grounds. There will be grounds. As to whether those grounds will pass muster, that is an issue for the court. But the grounds are there.
You cut me off when I was bringing the issue of whether we do indeed have a Supreme Court in light of what happened on the 25th. That we had a quorum hitch that was manufactured by political hands, and everybody knows this. So the question I'm asking myself is twofold. Even if there were to be a petition filed tomorrow, do we first of all have a Supreme Court in terms of the physical judges? Will they show up, first of all, to be present?
You say quorum hitch, you say quorum hitch.
They've decided in advance.
Let me finish. Will there be judges present to hear the case? Number 1. Number 2, even if they are present and seated there, will they be true to their oath that they will adjudicate that particular matter truthfully and with fidelity to the law and without fear and favor? I mean, it's easy for us to pontificate and say, these are people who have taken an oath and we pray for them and that they will show up. But those threats have not been made to us. Nobody has shot at me. Nobody has shot at Kamodho Waiganjo.
Threats.
Yeah, exactly.
Because you actually said everybody knows there was a political hand in this.
Yes.
I'm sure everybody knows. I don't know, for example.
I don't know. Yeah.
Now, this is the duty that we have taken up as NASA. Our job is to educate people. We will educate you.
Edwin,
but in order for us to be able to educate, you must listen.
Edwin is raising some concerns that were quickly overtaken because this happened on the 25th and the repeat election was on the 26th. So people really did not talk about what happened that day in the Supreme Court.
You are not allowing me to teach my brother. And he had asked me to give him the constitutional underpinnings of
Let's just finish with this matter first so that they can also respond to this. Doesn't he have a point? Doesn't Sifuna have a point when he says he's concerned as Sifuna and as NASA because of what we saw happen on the 25th of October, where we had David Maraga just saying only he and Lenaola are present, saying Justice Jokin Dungu didn't catch a flight, Justice Mohammed Ibrahim is ill, and didn't give a reason as to why the other 2 judges were there. Doesn't he have a point?
He has a point because I think the Chief Justice's explanation was not satisfactory because the judges have sworn to defend the Constitution and to serve without fear. If then you create a climate of fear that makes a judge, such as the DCJ, to refuse to attend to her duties, because what the Chief Justice said, all of us know what happened in the DCJ yesterday, that is actually to apologize that they are now giving in to threats and intimidation, and that doesn't augur well with their... So we can't neglect that aspect also. But what I would like to extend that list, I have another concern, and which is why I would have appreciated if this petition was truly filed so that we can test the fidelity, the commitment of both NASA and Jubilee to the Constitution and the judicial orders, because in terms of the bindingness, the question is this. Can we say with certainty, and at least on NASA's part, as Sifuna is here, can we say with certainty that if somebody filed an election petition and the Supreme Court nullifies that election again, that Jubilee is happy to go to a 3rd presidential election? Does Jubilee genuinely believe that the court can nullify that election? NASA, do they genuinely believe that this court can actually uphold this election, and then if the court upholds, they'll be bound by that decision and abandon election in 90 days? I think for NASA's part, Sifuna is able to clarify, because
that they're already concerned about what happened on the 25th.
No, those concerns are secondary to this one. This one, they're not. They can be processed separately. The concerns about the judges not showing up on 25th was not well explained, and anybody who tries to downplay that,
you know what happened. The difference between me and you is that I will call a spade a spade. Everybody in this country understands that the quorum hitch was manufactured by political forces, that people actually would intimidate judges not to show up. The Chief Justice himself alluded to it. If the explanation that was given by the Chief Justice as to the absence of those judges is satisfactory to you, there's something wrong with you. And what I am saying is this: people need to understand that when the Constitution says it is the duty and responsibility of each and every one of us to stand up for it and to defend it, don't sit and say, I hope NASA files a petition. it is your responsibility as well. The things that we fight for are not the preserve of the people in NASA. They're the preserve of everyone in this country who cares about electoral justice. So I will want to explain one of the things that has been raised by my colleagues here.
If we finish with this issue of Supreme Court judges
he said, yes, he said that we are now operating outside the Constitution. I would like for him, and I know that my senior has been part of the constitutional review process in this country. I would like for him to explain to the country what he understands by when Article 1 talks of us as a people being able to exercise the sovereignty donated to the president or to the members of parliament directly. When we are fed up with them, when we understand that parliament has been emasculated, we can set up a people's assembly. When we do not recognize somebody who's sworn in as president as being validly elected, we can reject his authority and exercise that authority directly.
Can I make 2 points? One, I find the reading of lawyers, and particularly those in politics, reading of the Constitution interesting. If you read Article 1, you'll notice the Sifuna and other people run to Article 1.2 because they don't want to read Article 1.1. What does it say? Sovereignty belongs to the people, but shall be exercised in accordance with the Constitution, which means you must go to the Constitution and find what is the forum through which you exercise that direct sovereignty, which means there are avenues that are given in the Constitution which allow the process by which you exercise direct sovereignty. That is why even when you have something which is an exercise of direct sovereignty like a people's referendum, it even gives threshold of numbers because it wants to ensure that even that process is a structured process. Because this is the danger. Let me ask Sifuna. In the county of Siaya, Honorable Gumbo, there was Honorable Rasanga won Honorable Gumbo. Are Honorable Gumbo's supporters entitled to exercise their sovereign rights and not recognize that county governments? Or is this something that is only available at the national level? When we go to the Constitution... No, I'm just saying because to show you... No, let me just finish. You
have to make out a case against Gumbo.
No.
The way we have made out a case against Gumbo.
No, that is... I'm just saying...
It's not just comparing apples and oranges.
I'm just saying as a constitutional point, are the supporters of all these candidates who won in Kisumu town, are they also entitled to ignore Honorable Anyang' Nyong'o and take over government because they believe that government is not legitimate? The Constitution has structures. That is why the Constitution exists. The Constitution exists to manage even the exercise of direct power. And it says how that will happen. And I think it's important for NASA to recognize that. They are the greatest defenders of the Constitution, they tell us. They must also ensure that the exercise they are seeking of direct exercise of authority is within constitutional confines. Anything else would actually be a violation of the Constitution and in breach of Article 3.
Yeah, but you see, Prof, one of the things that you are avoiding telling us is, for instance, when we say we are going to have a People's Assembly, is it outside the Constitution?
No, the People's Assembly...
The law is, you see, when we were being taught law, we were told that unless a statute says specifically outlaws a certain action, then you cannot impute illegality on that action. So which law is this that says a constitutional assembly or a people's assembly is outside the Constitution?
No,
there is no such
I don't think it's about a people's assembly because we even have a people's assembly. Bunga la Wananchi is still there and others. What I'm saying is, what do you want to do? You see, the problem is if you take that, whatever others say, we don't recognize, so we'll take over. In fact, the point you made was that you don't recognize the president, so therefore, as a direct, we can now operate in authority directly, which means, what you're then saying, that is a violation of the Constitution.
This is the problem.
This is how.
Where is the violation?
Just explain to him how.
Yeah. Where is the violation in Article 1.2? Because Article 1.2 presupposes that when you are exercising this direct sovereign power, these institutions still exist. You can forego the presidency as declared by the IEBC and say, this power, I am not donating it to you because I do not recognize you.
That process is what through an election.
Hussein, I can enumerate about 5 instances in which people can exercise their sovereign power directly within the confines of the Constitution. What we need to be careful about is not to manipulate the constitutional provisions, you know, as the point of departure and then start doing things that may be deemed to be outside the Constitution. If you want to exercise sovereignty or direct under the Constitution, the first and obvious one, you have an opportunity to elect your president at the ballot. The second, you have an opportunity to impeach him. You see, right now, that's an innovation that is now available under the 2010 Constitution. You can initiate, with your members of parliament, the process of impeachment. The Constitution also allows opportunity for direct participation, under Article 10. You may choose not to participate when the government wants to consult you. That's constitutional. Chapter 4 of the Bill of Rights allows you to also picket. That you can do within the Constitution, and Article 37, the right to, freedom of assembly and association. You can do that. And also the right of recall for members of parliament. So all these put together, these are the confines in which someone can exercise that direct authority. But, listen, what is not allowed or permitted by the Constitution is, for instance, to use, by way of demonstration, Article 37, which allows for freedom of assembly and association, to then veer off, and then now deliberately start disrupting the order of government. If you attack institutions,
if that is what you assume, that is what they want.
No. I'm just pontificating now, so that Sifuna can do the proper framing. But if you veer off the constitutional provision, remember the Constitution has the opportunity and the structure to reestablish itself. One way of the Constitution reasserting itself or reestablishing itself is that someone will move to court, the judiciary will find that, well, the manner in which you're exercising your right is not within the Constitution, and then required to confine yourself to the parameters defined by the Constitution. Now, if you are, for instance, you want to impeach the president, and the manner in which you do that, probably you don't have the numbers. That is a way in which the executive, through let's say the leader of majority, or maybe the members in parliament, can be able to minimize that. So what we say is this: there is no problem with people organizing. In fact, the civil society has been organizing citizen oversight forums for a long time. Bunge la Wananchi has been here. I don't find anything problematic with NASA saying that we'll organize citizen forums or Bunge la Wananchi. That is allowed. It's how they innovate within that, whether they're able to persist within the Constitution or whether they're able to veer off the Constitution. Okay. But then there are institutions to try and bring that back to
my colleagues at the beginning of the program said, even for us as NASA, we do not have the mandate to say what is constitutional or not, whether the election was held properly or not. I would also extend the same favor to them, that they are not the ones to tell us what is constitutional and what is not. If you have a problem with my boycotts, if you have a problem with my protests, if you have a problem with my establishment of a parallel system of governance, then take it to the courts. Let's see if the court will say that a people's assembly is unconstitutional. Okay. So it's not for them to sit here and say it.
Right. Let's go back to the.
We're here to give views. We're here to give views.
That's what I was doing.
I think what we are saying is that you can't make a final determination on the question.
So yours is also not a final determination.
No, it is not final. It's a view. It's a view, Sifuna.
Fine. Yeah. So let's talk about if that happens tomorrow, because now we are only 24 hours away to that deadline. First, we've seen some NGOs and our consortium that has already raised some issues of credibility with this election. We've seen them, their leaders being summoned by the NGO Coordination Board for allegedly contravening some regulations. First, how do you interpret this? I'll start with you. How do you interpret it? And the timing.
I'm hesitant to make a position. I'm very hesitant to make. Yeah, I'm very hesitant to take a position without the facts. Ifuna, I'm not in politics, so I prefer to see the facts. I think for me, it is not only NGOs. You see, this assumption that if civil society, one or two civil society don't go to court, the election cannot be challenged. It's not informed by facts. Kenyans go to court all the time. In fact, civil societies go to court the least number of times. The Omtatas and others are in court every day on issues of breach of human rights. So I expect that there is no necessary connection between the two issues. What I expect tomorrow, because I'm sure there are people who are aggrieved, is that there are people who will go and they will raise the issue. Some of those issues have been identified by Kura Yangu, Sauti Yangu. They are entitled to articulate those issues in court. They will articulate the question of why the election did not happen in 25 constituencies. Does that lead to the nullification of an election? Those issues can be articulated by any Kenyan. They don't need a civil society body. So that's why I'm trying not to attach the two and to assume that if you are to act against civil, that a petition will not go ahead. Kenyans go to court all the time on these issues. Okay,
Sifuna.
One of the things that we were discussing in the room before we came to your show, saying, is the fact that as human beings, we need to call what we see as what we see. If something is wrong, something is wrong. There is nothing like coincidence in this country. It is not a coincidence that after the elections in August 8th, during this same period when we were expecting petitions, we saw the government crack down on some of those organizations like Africa because they thought they were the ones who were going to file these petitions in court. It is happening again. It is not a coincidence, Hussein. This is a pattern that has been established by this regime. They think that by incapacitating some of these organizations, because as you can see even from this table, there are people who have ceded their right to defend or their duty to defend the constitution to others. My brothers here will cannot go to court. So those organizations that are known to go to court want the government only seeks to incapacitate them. There are people here who think it is the responsibility of Sifuna and his NASA brigade to defend the constitution, as if they don't live under that constitution. So we all know what is happening with the NGOs Council. Even though that body is an illegal body, it was, outlawed after the coming into force of the Public Benefits Organizations Act. But the government still uses it to silence its critics.
This is the NGO Coordination Board.
Absolutely.
And just for the record, they are saying, they are calling them, for example, Inuka Kenya Katiba Institute and Muhuri. Their representatives will go before the board tomorrow to respond, for the record, this is what the board says, to a series of audit, registration, human resource, and finance queries.
That's euphemism.
I think Hussein, I disagree sharply with Fazul on that approach, because first, he has made an assumption that the NGOs are doing something wrong, the civil society organization. The procedure is, if you doubt the manner in which an organization is operating, you write to them, making inquiries, you give them an opportunity to respond effectively. If there's need for further follow-up, you can do that. But this kind of a posturing is what now maintains the perception that truly the government is now zeroing in or maybe persecuting civil society organizations that are too critical. What I want to tell the government is, and all actors in the governance sector, it is not, the civil society need not to apologize for having a shared or a conflict of interest with the political opposition. Because if you see, the role of the political opposition is to check and oversight government. The civil society also does the same thing. So if you share a similar objective, one need not to apologize, and the government must realize under this constitution, a robust, independent, and critical civil society is actually a necessary requirement in the order of government. But insofar as the petition is concerned, I would say this.
Do you see it having anything to do with this filing of a petition?
Well, I think, yeah, it's possible, yes, because you see, Kenya Human Rights Commission, ICJ, Africa have previously been targeted for, these are organizations that work in human rights and governance sector, which most of the time are at loggerheads because of fault finding the government continuously. So the temptation to try and crack down or limit their space cannot be underrated. But what I would like, you asked a question about the merits of filing a petition. Let us not assume or maybe underrate the benefits of filing a petition. Actually, a judicial inquiry, a sober, dispassionate assessment of the electoral process is actually intended to be beneficial to improve election management. There are questions I would like IBC to clarify in a very neutral forum, such as the courts. For instance, the question of what completely went unattended and was not well explained by IBC. Raila Odinga withdrew his candidature on the 10th of October. Now, at the time when Raila was withdrawing, the only law in place was the 2013 presidential election judgment, which says if a candidate withdrew, the election stood cancelled. Now, IBC, through innovation, because they knew that on the 11th of October, Justice Mativo was going to deliver judgment in the Kuru case, they said, let's wait and see then how we can address these issues together. I would like clarity. What was the implication of that Raila withdrawal on the 10th, when the only law at that time was the 2013 judgment? To inquire into that issue is actually beneficial for this country, because if it is found that IBC was complacent or incompetent in terms of reading the law, also Article 163 sub-Article 6 allows IBC to seek an advisory opinion where they can't agree, where they can't have a shared or harmonious approach. So that question will probably go unattended and unresolved if nobody goes to court.
And also, there's another important benefit, Steve,
yes,
is that going through that process, if the election is validated, also legitimizes government, whoever won the election. If it is not, it then responds to some of the issues that were raised by NASA. So ultimately, as a country, we benefit through that process.
Yes.
I think the point, and to make it very clear to Sifuna, I have no problem with civil society. By the way, I'm a great supporter even of people like Katiba Institute. We have worked together. What I am trying not to do is to connect the two issues. My own view is that the civil society is a very important plank of any constitutional democracy. It is good for Kenya, and they must be encouraged. And it's important. The amount of work that has been done by people like Katiba Institute for Constitutional Development is commendable. I think what I don't want to go into, because that is not
to connect the two.
Because
the timing does not strike you.
That's conspiracy theorizing, which for me I don't find useful. You know what I mean? I think let's deal with the facts. When the facts are brought about whether these institutions have breached the law, then at that point, because let's assume there's a breach of the law, should we we have waited until when? Now, if we find there was no breach of the law, and remember, we also have the courts to adjudicate on this issue. If we find there was actually no breach of the law and this was harassment, then of course the government stands indicted. But I think to assume that they are innocent, so therefore the only reason is also wrong. So I'm just saying, let's wait for the facts.
Nobody can. We shouldn't assume anything because they're going actually to list.
Yeah, and they haven't been. They've been told to go and explain.
Yeah. But I'm asking you about the timing because within the 7-day period, within somebody can file a petition. The same period after the August 8th election, we had this NGO board run-ins with these bodies. Again, happening this same period again after the 26th election.
I mean, there's reason to, one can suspect. I mean, I think one can have a view. I don't think I'm saying it is not possible. All I'm saying, I don't think it's a useful inquiry as to whether this is the reason. From where I sit, it is not useful. Let us wait for the petition, because they are not the only ones who can file a petition. So even if the government was to stop the 3, and there are 40 million Kenyans who have filed petitions. So I don't think it's a crisis on the petition. That's the point I'm making.
Okay, finally, now that you've talked about grounds, when you're talking about Raila's withdrawal, and just for the record, I mean, to be fair to IBC, this is what they said, that the commission cannot compel a candidate to participate in an election. The law allows a candidate to withdraw his or her candidature by delivering to the commission a duly filed Form 24A. You remember how they explained that? And that the form is provided for by the election general regulations. Apart from this, and to all of you as you wind up now, what other key, because there are many, but key, there could be many or not, but key, key areas or key issues you think that could, if anyone goes to file a petition, would use in that petition?
I think, Hussein, that issue that he brought up is the most important issue that I want to see.
The withdrawal of
absolutely, because you will remember that the 2013 decision was a unanimous decision, meaning 4 of the judges who reached that decision in 2013 are still presently sitting on the Supreme Court. So I would like to see what legal gymnastics are employed so that you move away from that position. That is the most interesting question for me. Number 2, there is a question of the irregular gazettement of people as candidates after you've already printed the ballot papers. You will remember that people like Jirong, who are being added who are being gazetted as candidates way after the ballot papers were here in the country. So we would like to see what the Constitutional Court or the Supreme Court says about those issues and whether that election can actually stand the scrutiny and the standard of the Constitution.
Well, I think something that may be beneficial for clarification if there's a petition at the Supreme Court was the issue of the voter turnout. I think it's a sticky issue that is not well explained. People who are aware about the election management, the presiding officers were required at every instance of 9 a.m., 11 a.m., 1 p.m., 3 p.m., 5 p.m. to send the voter turnout via text message to the constituency returning officer, not for his own amusement, but to collect all this, and then forward this to Nairobi National Tallying Center. So it's possible, Hussein, that at 5 p.m. or shortly after 5 p.m., the first level of knowing voter turnout through the text messages, leave alone what was keyed in as the logs in the KIMS, that shortly after 5 p.m., because the law says, at the close of voting, you text the returning officer. Every presiding officer texts the returning officer the voter turnout. It's not for his own, just to look at them and then be happy, be amused with those figures. To collect them and say, Langata constituency, for instance, I have 100 presiding officers. This is the total voter turnout. Then I transmit it to Nairobi National Tallying Center. Then, so it's possible that when the chairman is tweeting a voter turnout of 6.5 million, that is actually the final figure. The law does not allow for provisional voter turnout. What was called the logs, at the end of the counting and the counting and announcement of results, as you are sending them electronically, there was a space there to key in the actual voter turnout that you sent via text message. That is what perhaps would take long. Remember, the Supreme Court asked the question, how long does it take network to pick? If you send here, you walk to a place where there's network. So if not well explained, I think that issue may be problematic and may cost Uhuru the presidency. So these are the issues that if they were taken to court and they were properly clarified, then I think the question of legitimacy would be beneficial even to Uhuru Kenyatta. So I see that as the critical issue that was not attended to.
I suspect that the question I mentioned earlier about the provisions of Article 138(2) that requires elections in every constituency, and the fact that the elections did not happen in some constituencies, that is going to be raised. That, of course, will be measured against the provisions of Section 55 that allows for the election to be called. So that will, the question of the constitutionality of that provision, that will be brought into question. The question of the returning officers, the decision by Justice Odunga, which was eventually stayed by the Court of Appeal, I'm sure that issue will be relitigated again. The question of maybe there are also other irregularities. We have seen some issues that have been raised by Kuriangu Sautiangu about some forms, tampering with forms. Those issues will be adjudicated by the court. At the end of the day, the important thing about that process is that when the court finally says this is a valid election, that discussion stops until 2022. Of course, the political level, it can continue to be agitated. If the court says that this was not a valid election, we'll go back to the ballot. But I think it is important, and the answer point I want to end, it is important that whatever we do, we paid a heavy price. Kenyans paid a heavy price for this constitution, that we must always operate within its letter and spirit, and not be innovative in a way to try and violate it, because I think that's what's happening in some quarters.
Okay. Hussein, just one thing. Legitimacy will be derived from the people. There is no judgment that will come from the Supreme Court that will give a government of Uhuru Kenyatta legitimacy. It doesn't have it.
Well, the legitimacy is also, legitimacy depends on who.
The court is not a laundromat where you take in trash for you to get clean. It's not possible.
As I want to say on legitimacy, you see legitimacy, even in America, if you go to America, the people who voted for Trump thinks it's not legitimate. So that is okay. And I think that is the freedom of choice and freedom of expression is to say, I don't find you legitimate. Honorable Professor Makau Mukua says that is not his president. That does not stop the president from being the president. So what you are saying, legitimacy issues are political, but legitimacy is a legal construct. Once the law says 50% plus 1, 25% in half the counties, that is legitimacy.
Okay. Sifuna, you're saying there's a comment you just made about the courts, that this is not just a laundry you can take your...
Yeah, the courts are not a laundromat. They will not clothe you with legitimacy that you do not have.
So if somebody goes to court, Sifuna, tomorrow... No. What I'm saying is this. Yes. In the circumstances of this charade that happened on the 26th, there is nothing short of the second coming of Jesus that will clothe this Jubilee government with legitimacy. So if somebody goes to court, my question to you is, somebody goes to court,
yes,
and this election is upheld,
yes,
what happens? You're not going... I mean, how do you treat that? Because me, you're talking as Sifuna, you're talking as NASA,
yes,
and Sifuna. We are in this process today because an election was nullified on the August 8th. And NASA actually praised the Supreme Court for what they did.
Yes.
So what are you saying now about the court again?
That's what I'm telling you. It doesn't matter what pronouncement the court will give. It can legally uphold an election. It will not give you legitimacy. We are saying you will not derive legitimacy from a third of 1/10 of a population. We will not accept you as our president. It's that simple.
And I think that's okay. I mean, that is what the Constitution allows the right to. No, it's to say...
We are in agreement.
That legitimacy at the end of the day in law, constitutionally, is what the Constitution calls legitimacy. Okay. Everything else is a view which is legitimate.
There's the legal legitimacy and there's the political legitimacy. What Uhuru may not get is that political legitimacy.
From NASA supporters.
From NASA supporters. Yeah. Because but the legal legitimacy, insofar as he was declared as the winner, the election, and that election is upheld by the court, the legal legitimacy and the mandate to govern, he'll receive it. But however, because even the Constitution requires a more consultative, deliberative, and negotiated approach to governance.
Okay.
So without bringing people together and having a national dialogue and discussion around how to move this country forward, that political legitimacy question will be a significant deficit in his tenure. I think that we cannot underrate that.
All right, this statement I have to read very briefly is just a caution from the Kenya National Highways Authority, KENHA, that says that the Kainuk Bridge, which had 2 weeks ago been affected by heavy flooding from the northwestern region, I think this is in Turkana, may now be completely unusable by all traffic and pedestrians. KENHA says, we urge all members of the public to observe absolute caution on this section of the Kitale, Lokichar, Lodwar, Nadapal corridor. And they say, additionally, apply absolute caution on all drift areas along this corridor. Thank you so much for your time tonight. Very interesting discussion by lawyers here, Kamodo Waiganjo, Steve Ogola, and Edwin Sifuna. The next 24 hours are clearly very interesting. We'll see how that pans out. But thank you so much for watching Sunday Live. I'm Hussein Mohammed. Have a good night.